Thank you, and good morning.
Good morning, Your Honor. Dan Crane on behalf of the defendant.
Thank you, and good morning. The court received and has reviewed the parties' joint statement of discovery or disclosure dispute regarding business records, lost income damages, and related financial records. Before the court provides some of its own thoughts, the court wanted to hear from the parties regarding their positions, anything they wish to share with the court. So we can start with plaintiff's counsel, and then I can hear from defendant's counsel, Mr. Crane.
Yes, Your Honor. Your Honor, we believe this dispute is considerably narrower than the defendant's statement suggests. The plaintiff here has never refused to produce the business records that support the lost income claim, and she does not resist her obligation under 26(1). What plaintiff did object to are two requests that seek something entirely differently, namely the name, contact information, and hiring decision of every customer and prospective customer she has ever solicited on social media, and every document reflecting any solicitation, outreach, or marketing effort her small business ever made. Now, I only want to highlight 3 points this morning. First, the request as actually served was overbroad and disproportionate, which we highlighted because they seek non-party identities and marketing materials rather than damaged records. Second, plaintiff has affirmatively offered defendant everything defendant legitimately needs on a concrete timeline and with a protective order where appropriate. And third, the alternative request here for preclusion is a drastic sanction here that is generally reserved for circumstances not present here. Now, with regards to the overbroad, first I'd like to go and focus on what the interrogatory number 6 and request for production number 6 actually say, because defendant's statements describes them as requests for financial records, and they are not. Interrogatory number 6 demands that plaintiff identify all customers and potential customers that she has solicited on social media, including their names, contact information, and whether each one hired her. Request number 6 demands all records reflecting plaintiff's business solicitation, outreach, or marketing efforts during the relevant time period. Neither request is limited to the incident, to defendant, or to plaintiff's claimed losses. Now, with Rule 26B1, it permits the discovery only of matter that is both relevant to a claim or defense and proportional to the needs, considering, among other factors, the importance of the discovery and resulting the issues and whether the burden or expense outweighs its benefit. Now, the identity and contact of every stranger plaintiff has ever messaged about a cleaning estimate has no tendency to prove or disprove the income she lost after defendant exposed himself to her. Lost income is proven through booking records, cancellation records, the screenshots provided by defendant in their disclosures to test the numbers. Now, the non-party privacy concern is not theoretical here. These are individuals with no connection to this lawsuit whose personal contact information would be handed to the man charged with indecent exposure arising from this very incident and to his counsel. The record in this case already shows third parties inserting themselves into this dispute, including the negative reviews posted against plaintiff's business by a stranger who admitted they left it on behalf of a friend and had never used plaintiff's services. This is precisely the environment in which a court should be cautious about ordering a small business owner to disclose her entire customer and prospect list. And if any customer identifying information becomes necessary, it can be produced under a protective order, Your Honor. Second, to highlight the fact that plaintiff has offered everything defendant legitimately needs. Plaintiff can supplement the 26.1 with a computation that can support revenue and booking records, missed appointments, cancellation records. Now, plaintiff proposed to complete that supplementation, or has proposed to complete that within 30 days of the ruling, and it can cover the period from 1 year before the incident to present, which is a reasonable pre-incident timeline baseline, not an empty and open timeline as the interrogatory or the request for production demanded. I would also note that plaintiff's initial disclosure was not silent on damages as defendant claims. Section 7 disclosed the categories of damages and the presently available figures, including the estimated counseling general damages tier, and the computations. Now, plaintiff has already produced documentation of reputational impact on her business, including the review campaign that followed the incident. Now, defendant may argue that this evidence is insufficient to prove her damages, but sufficiency of plaintiff's damages is a merits question, either for a summary judgment or a trial. It is not a basis for refusing to accept her discovery objections or sanctioning while discovery is open. And finally, Your Honor, I just wanted to briefly go through the preclusion that's been requested by the defendant. The defendant's alternative request that the court preclude the plaintiff from offering any evidence of lost business income is not proportionate response to a dispute about the scope of two discovery requests. Now, the Arizona Supreme Court has made that clear that the purpose of disclosure rules is to give the parties a reasonable opportunity to prepare for trial, and that disclosure is not intended to operate as a trap or a sword. That was in Byron v. Riddell. Now, the Court of Appeals has likewise instructed before excluding evidence as a disclosure sanction, the trial court should consider the prejudice to the opposing party, and it has observed that the factors supporting exclusion gain strength as trial nears. And this court, again, retains broad discretion to fashion a reasonable remedy short of preclusion. Every one of the considerations here cuts against preclusion. There is no trial date. There is no trial setting conference. The trial setting conference set for November, and the parties have stipulated to amend the scheduling order. Discovery is open, and plaintiff has proposed concrete supplementation within 30 days. Defendant has identified no prejudice that would not be cured, and Rule 37C itself protects defendant going forward, because if plaintiff fails to disclose the record she intends to rely on, she will not be permitted to use them. Preclusion today would punish plaintiff for asserting good faith objections that she paired with a compromise offer, and it would eliminate a category of damages in a case arising from conduct for which defendant has already pled guilty to a criminal charge. Now, as to the request for defendant's fees under 37, plaintiff's objections to the request seeking non-party identities and all marketing material were substantially justified under 26B1, and plaintiff coupled those objections with the proposal that gives defendant the damages records he claims he needs. So if the court denies the motion as to the customer list and marketing materials, Rule 37A5B would authorize an award of expenses to plaintiffs, although plaintiff is content to have each side bear its own expenses if the court adopts her proposed resolution. So finally, Your Honor, here the plaintiff is respectfully requesting that the court deny the motion and compel as the identities and contact information of non-party customers and prospects, and as to plaintiff's unrelated marketing materials, order that any production containing customer identifying information proceed under a protective order pursuant to 26C, adopt plaintiff's proposal to supplement her damages computation and produce her business records within 30 days, covering 1 year before the incident to present, and deny the request for preclusion and for fees. Now, unless the court has any direct questions, I'll reserve any remainder time, Your Honor.
Thank you, counsel. I'll go over to Mr. Crane.
Thank you, Your Honor. I want to just start by pointing out some of the obvious problems and the reason why this discovery dispute was brought. As of and up until our side reached out to extend the schedule to get these business records that we've been seeking so we can effectively take plaintiff's deposition, we already have discovery, and that's closed as of right now until the court enters an order. So for plaintiff to come in here and tell the court that she is willing to provide documents, she's already missed the deadline to provide documents. So, respectfully, we appreciate the fact that plaintiff is willing to provide business records for a year before and a year after. We would ask that the court enter an order she provide those records before her deposition is to be taken, and in the currently proposed schedule that both parties submitted to the court, her deposition would be taken on or before September 4th. So 30 days just isn't sufficient when we're going to get those documents. Next, I want to address, I guess, kind of a point that was raised with the computation of damages. The current disclosure statement, which I have in front of me from plaintiff, does not have any computation for damages for lost business income and lost business opportunity. And it says instead it's going to be in an amount determined through review of business records and expert analysis, which is a quote from it. The deadline to disclose expert reports has already passed, and the parties did not seek to extend that. And so as a result, we're not sure exactly how we're supposed to determine what damages plaintiff is actually seeking from her 26.1 statement, which we're happy to provide to the court. But we believe we, one, need the records so we can challenge the damages she may provide, and two, she should provide a computation or she should withdraw those claims. Next is to the customer list. Plaintiff has made public statements that she has been unable to go out and solicit new clients as a result of the incident. As a result, that she has gone out and solicited clients is of material relevance, and who she has solicited is also of material relevance, so we can challenge that. Plaintiff said that they have refused to provide it subject to a protective order, but the defendants have actually reached out to the plaintiff about whether or not they need a protective order and did not receive a response. We're happy to hear today that plaintiff is willing to agree to would provide those records if we have a protective order, and the parties can certainly work on getting that submitted at the utmost haste. Ultimately, Your Honor, what we are looking for are business and financial records so that we can challenge damages that has yet to be disclosed, even though we're beyond the current close of discovery. We're also looking for customer solicitation, and I do want to make a point so the court knows that the time period that we requested the customer solicitation is not the entire customer list. We asked for 3 months before the incident in question and 3 months after the incident in question, a 6-month time period where we are looking for the solicitation and the outreach. It's important to identify, or at least point out, that part of how plaintiff does business, she does direct messaging through social media and social media posts. So she goes through social media, she identifies clients, and she solicits them. Defendants should be able to challenge and show, or at least challenge, if plaintiff her solicitation behavior as a result of the incident in question or not, and so we should be entitled to those records. So as a result, Your Honor, we're asking that the court order the plaintiff to produce the business records that she has offered to produce, but we would ask that those be produced in advance of the September 4th deposition deadline. We would also ask that the court order she provide her solicitation records for 3 months before the date of the incident in question through 3 months after the date of the incident in question. The incident in question was on September 23rd of 2025. If the court has any questions for me, I'm happy to address them.
Thank you, counsel. And counsel for plaintiff, could you repeat the pronunciation of your last name?
Yes, Your Honor. It's Damui.
Mr. Damui, thank you very much. Anything? Mr. Crane raised the scope of time of 3 months before, 3 months after, as to the response to the interrogatory number 6 and request for production number 6. I wanted to give you a chance to respond to that. I'm not sure you directly responded to that issue.
Sure. We have no objection to that time period. Now, what I will say, it's something that they mentioned was with regards to the protective order. Now, if Your Honor grants their motion, then surely that's the route we'd go. But simply us producing the customer list under a protective order in our position does not resolve this dispute, because the protective order addresses the confidentiality, Your Honor, but it does not create relevance. The names and phone numbers of prospects who never hired plaintiff have no bearing on her lost income. To the extent that the identities of paying customers appear in the revenue booking and cancellation records, plaintiff is offering to produce, but that's not all that they're asking for. They're asking for every single person that she had solicited her services to here. So we, under protective order, we're more than happy to provide the ones that ultimately either had a relevance to this case, but the ones that never ended up either responding, or there was no follow-up, or had no connection to this case, we believe that a protective order, again, or rather, we believe that the protective order alone is not going to resolve the relevance issue on that matter, Your Honor.
So I guess I want to understand, as to interrogatory number 6 and RFP number 6, the argument the plaintiff is making regarding the incident and claimed economic or reputational loss. I mean, how does play? It would seem to me that if plaintiff is going to argue that there are customer solicitations of prospective customers, marketing and related records that were impacted by the incident that was alleged here, that those would be discoverable. So I'm just trying to find a line here for what I mean, what the court would be inclined to do is order that to the extent that plaintiff is contending that that solicitations, outreach, marketing, interactions with prospective customers were affected by the incident or are going to be relied upon for the losses, those would seem to be discoverable. But do you disagree with that kind of, I guess, limiting language?
Not necessarily. I believe that limiting language is sort of what we're looking for here, because again, as defendants sort of alluded to, a lot of the marketing, if you will, for my client's business is done through social media, whether it be her messaging people or posting in groups, whatever it may be. And oftentimes that leads to nothing. That leads to no response. That leads to nothing. Those we believe should have no relevance on this. Now, there are others which we've already submitted one of where the response is directly related to this incident, saying, no, I'm not going to hire you because you're falsely accusing so-and-so of doing so-and-so. That's one that we've already provided. We've provided 2 screenshots of those. We believe those are the types that should be allowed, and with the protective order, we would request. But the ones where nobody's responding, these mass, posting in large local groups, things of that nature, where any sort of interaction, like I said, we sort of want to distinguish and put people into 2 categories: the ones that respond with alluding to this incident and not wanting to use her because they think she's lying about this or whatever it may be. Those we believe are relevant and can be protected by protective order. But this second group that we're talking about, the people that don't end up even responding, whatever it may be, that we believe is not relevant. Even with the protective order, it doesn't solve the relevancy issue.
Thank you. Mr. Crane, anything further before the court provides its own thoughts?
Yeah, Your Honor, just to, I guess, add one little small point to that, which is plaintiff has conceded that they would provide financials. They've conceded now that they would provide solicitations for outreach that has resulted in either commentary on the incident in question or has resulted in successful client relationships. Ultimately, plaintiff has made statements that she has been unable to go out and solicit more customers. And so as a result, she's lost business. So again, Your Honor, we would ask that we should be getting every solicitation. We're fine with it under a protective order for the 3 months before and 3 months after, so that we can actually, quantify and measure the outreach she has had. Did she quit soliciting people? Did she solicit the same number of people? All of that is going to go to the plaintiff's credibility at trial, as well as to her measure of damages.
Thank you, counsel. So I am going to order that by August 28th, so a week from today, that disclosure be made of plaintiff's computation of claimed lost business income or business opportunity and the methodology used to reach that computation, that the production be made of the existing business records that would in any way support that computation, and identify any witnesses on whom plaintiff is relying to establish those damages. And the time range should be from September 23rd, 2024 through the date of the production. The court will deny going back any further without prejudice to later motion if it's deemed, if there's good cause to seek additional time going backwards. As to the interrogatory number 6 and request for production number 6, they're granted only as to customers, potential customers, solicitation, outreach, marketing, or records pertaining to those topics that plaintiff contends were affected by the incident or relied upon to establish economic or reputational loss. Any broader discovery than that, the court is going to deny without prejudice to a later showing. As to the protective order, the court's going to require the parties. So it sounds like there's a protective order that's circulating.
Your Honor,
not at this point, to my understanding, Your Honor.
Your Honor, we have reached out about whether or not one was needed. We can certainly send one over to plaintiff by Monday.
Okay. So the parties are to work to complete a protective order in advance of that August 28th, 2026 production. The court's going to deny without prejudice the request for preclusion at this time. Whoa. I'm looking to see if there's anything else. Are the parties on the same page regarding the dispositive motion deadline?
Your Honor, yes, I think the dispositive motion deadline, or at least the joint stipulation that the parties filed on August 12th, has the dates that the parties agreed to extend, which pushes out the dispositive motion deadline from August 28th to October 16th, which we think should be sufficient, with plaintiff's deposition being accomplished on or before September 4th.
All right, thank you. And the court just reacted to something just a minute ago. Just to clarify, I have a leaky pen, so I have a little ink on my hands. That was the reaction. I didn't want to cause anybody to speculate otherwise. Anything else that the court can assist the parties with at this time?
Just clarification, Your Honor, with regards to the records of for production for that request. I just want to clarify. So are we limiting it to those that have interacted or responded, or is it anyone that she's reached out to in any way regarding her business?
Well, it's really, in the court's view, at least at this stage, it's based on if the plaintiff is making the argument that that marketing, that outreach, that solicitation, that communication with prospective customers or actual customers were affected by this incident, then those documents and those interactions are discoverable. The court doesn't make any findings as to whether they would be admissible, but that they are discoverable.
Okay, so if she reached out to anyone during these relevant time periods that you mentioned from the September 23rd to the date of production, if she sent sort of a mass message that's a copy and pasted message regarding her business and what they offer, and she sent it out to, and again, I don't even know if this is accurate, but if she sent it out to 500 people, we would need that each one from those, even if out of those 500 people, only 10 people responded either positively or negatively, we still want to disclose all 500 of those, or just the one?
It depends on if plaintiff is arguing, because again, I haven't seen this RFP or this interrogatory, but to me, the scope that seems correct here is that if plaintiff is arguing that their efforts were that a specific effort was affected by this incident, then that effort needs to be disclosed.
Sure.
This is discoverable.
And we believe the efforts that, I mean, because there's obviously a number of reasons people could not respond to your message, and we're not speculating as to exactly what those reasons are, which is why we're limiting it to the ones that responded negatively and said, no, we're purposely not going to use your business because we think that you're lying about this incident and so forth. So those are the ones that we can, without further speculation or without, other potential, I guess, reasons being involved. Those are the ones that we're certain of that had a direct effect on her business. And those are the ones that we can prove through those messages. Now, again, when we're talking about the number of others who just don't respond, now we can speculate that they're not responding because maybe it did have something to do with this incident, but we can't necessarily, we can't speculate regarding that. So we're not using those as a barometer here. We're using the ones of people who responded to her, either advertisement, marketing, or otherwise, and specifically said, because I think you're a liar, because so-and-so in this specific incident, we're not going to use you and we're going to actually leave a negative review or something to that nature. That's sort of what we're utilizing in terms of our calculation of lost business records, because, as I mentioned, because of the fact that the nature of her business involves reaching out to lots of people in the area, it's hard for us to determine whether just the people that don't respond back have any knowledge of this incident or not. So for those reasons, that's what we're focusing on, which is why we believe the other ones may not really have relevance to any computation for us.
Your Honor, may I just address that? Because I do
Just
think
briefly,
that's-
because we are nearing the end of our time.
Yeah, I do not understand what was just said to be commensurate with what the court, I guess, is ordering. So I do want to be clear, because if plaintiff is claiming, and I'm looking at her disclosure statement, that she's lost business time and opportunity and reputational business impact, I still think we're entitled to all of her efforts to solicit her business before and after, so that we can evaluate if there was a change, not so plaintiff in her own selection of whatever messages she wants to provide. I mean, that doesn't provide us a fair opportunity to challenge it. So we understand the court's order to be clients, potential clients, the outreach she's had during the relevant time period.
But limit to, if plaintiff contends that this time period there was an impact on her business, or an economic or reputational loss, then there needs to be the customers, prospective customers, and solicitation, outreach, marketing, and related records that plaintiff contends were affected by that incident. So I'll leave to the parties that determination, because I don't want to define plaintiff's damages theory. So I want to be careful here, not to define that, but to the extent that there are any records that contain the universe of your damages theory, that contain the universe of your of plaintiff's claimed loss, and the universe of what plaintiff is contending were the customer interactions, prospective customer interactions, solicitation, outreach, and marketing that was affected by this incident, then those records need to be disclosed for the 3 months before and the 3 months after, as of August 28th, 2026. If they're deemed to be insufficient, I guess the court can hear a further challenge, but I think that's where the court sees an appropriate kind of definition of what's discoverable at this time and proportional at this time.
Understood, Your Honor. Thank you.
Anything else before we adjourn?
Nothing from
Nothing
defendant,
from plaintiff, Your Honor.
All right. Well, thank you very much. And hearing nothing else, appreciate everybody's time and effort, and this matter is adjourned. Thank 109, matter of McCarthy et al. Versus Ferris et al. If counsel could please announce for the record.
Good morning, Your Honor. Samuel Doncaster, Fraud Fighters Law, on behalf of Sarah McCarthy and Scott Shermer, the plaintiffs.
Thank you. Good morning.
Good morning, Your Honor. Troy Roberts representing Teresa Ferris, defendant and counterclaimant.
Thank you. And good morning.
Good morning, Your Honor. Samantha Sawyer for 480 Realty Property Management and Mario Montoya.
Thank you. And good morning.
Thank you, Your Honor. Mike Obert on behalf of Shannon Wellman, eXp Realty, and Steve Hutter.
Thank you and good morning. The court held, or scheduled rather, this status conference to discuss the parties' various filings regarding the joint scheduling order, or the scheduling order in this case. And I wanted to take those issues in turn and provide the court's thoughts on those issues so that the parties can have the court's orders in that regard. Is there anything the parties wish to take up? Given I know we have limited time, I can probably give more than 15 minutes, but I don't want to take too much of the parties' time. Is there anything the parties wish to bring to the court's attention before the court provides some of its own thoughts? Sounds like no. So I appreciate everybody again being here, and please speak up if the court is skipped over something that the parties dispute and the parties wish to discuss. This does appear, I don't know if I need to check